This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. For our final presentation, I have the pleasure of introducing Stacie Hausner, the Honorable Barbara Johnson, and the Honorable Ramona C. Stacie Hausner has been a full-time mediator with ADR Services for the last 5 years. She has an exceptionally high settlement rate and has mediated more than 500 disputes in the areas of business, personal injury, employment, real estate, insurance coverage, construction defect, and intellectual property law. Ms. Hausner has an LLM in Ms. Hausner has an LLM in dispute resolution from the Strauss Institute at Pepperdine University School of Law. And when she is not mediating, she teaches mediation theory and practice and advanced mediation at the Strauss Institute at Pepperdine School of Law. She also spends time training mediators for the Central District Court panel and the Mediating the Litigated Case program at Strauss. Next, we have the Honorable Barbara Johnson, who's retired from the Los Angeles Superior Court in 2020 after 27 years on the bench. She enjoyed a distinguished judicial career as a respected trial judge with an uncompromising approach to legal adjudication with assignments in probate, the appellate division, and the criminal department. Her lifelong commitment to promoting justice and making decisions based on fairness and reason now extend to her work as a mediator, arbitrator, referee, and private judge with ADR Services, Inc. Last but not least, we have the Honorable Ramona C., who's joined ADR Services in 2021 after spending over 2 decades as a judge of the Los Angeles Superior Court, where she earned a reputation for being an incredibly bright, hardworking jurist with a strong legal mind. During her judicial tenure, Judge C. presided in an independent calendar court for 20 years, handling cases from commencement through discovery, pretrial, and trial in a broad range of civil matters, including business, real estate, employment, personal injury, construction, insurance bad faith, medical and legal malpractice, wrongful foreclosure, breach of fiduciary duty, and others. She is highly regarded for her intelligence and thorough preparation, supplementing her exceptional depth and breadth of legal knowledge with additional research as needed. Judge C also served as a settlement judge in numerous matters, utilizing her excellent judicial temperament and respect for the parties and counsel alike to help disparate sides come together and reach a resolution. So I pass it on to you, presenters.
Well, thank you, Hayward. We appreciate that. I've been assigned to proceed first, and I want to welcome and say good afternoon for those of you that are joining us just now and for those that have persevered since this morning. Our last session today for the MCLE, we appreciate it. We're going to be talking a little bit of various areas concerning ethics, of course, and especially the rules of professional conduct. As we all know, the State Bar is the attorney licensing agency for lawyers. And we will begin the presentation by reviewing portions of the 2020 State Bar Report, which includes a statement of the mission of the State Bar, the annual discipline report as included in the State Bar Report, and a brief discussion about COVID and its effect on the discipline processes. The mission of the State Bar is to protect the public. The public is protected. I've got to put my timer on here. The public is protected in part by the Office of the Chief Trial Counsel. The obligation of the Office of the Chief Trial Counsel is to investigate and to prosecute complaints against attorneys and work with law enforcement to stop those who falsely hold themselves out as attorneys. The 2020 annual State Bar Discipline Report provides a picture of the work of the disciplinary system. The report includes statistical information as follows, which includes the following. First, there are over 260,000 licensed attorneys in California, with 190,000 on active status. The State's Bar's Office of the Chief Trial Counsel, OCTC, we'll refer to it as that, opened 17,500 cases, a decline of 4%, believe it or not, from 2019. And they had notices of disciplinary charges against 180 attorneys in the State Bar Court, which is an increase of 28%. The OCTC opened 600 cases for the unlicensed practice of law attorneys or people who were practicing law without a license, and referred more than 300 unauthorized practice of law cases to law enforcement. Recommended discipline was given out to 211 attorneys, including 97 disbarments and 114 suspensions. They also issued 50 approvals. The State Bar also distributes restitution type funds to victims who have incurred a financial loss due to fraudulent and theft or dishonest conduct by attorneys. As a result of this, of over $11.75 million was distributed through the Client Security Fund of the State Bar. And this was allowed because of a one-time fee increase for the security fund. As a result, over 830 victims of misconduct and fraud were reimbursed. Now, we all know that we're still kind of in a pandemic, but during the pandemic, the State Bar prioritized cases according to the greatest risk or harm to the public. And even though before the beginning of the pandemic, the OCTC had a huge backlog of investigations that needed to be addressed, that backlog became a priority during the pandemic. With licensing fees increased, the first in 20 years of the State Bar was able to prioritize and differentiate between egregious conduct and behavior of attorneys and low-level priority cases. The State Bar cut back the backlog of high priority cases by half, and now those cases are 17% of the backlog. And the State Bar was able to obtain new staffing. Despite the pandemic, though, the State Bar briefly closed its in-person court proceedings. The new case management system enabled the State Bar to shift its discipline functions to remote work. From April to December, over 1,300 remote proceedings were had, including status conferences, trials, and oral arguments. Moreover, because legal activity throughout the state was impacted by COVID, fewer cases were filed with the state court, and therefore the cases filed were down 14% from 2019. The takeaway is that just like the IRS, the State Bar is catching up on its backlog, and the complaints still pending will be investigated and, if necessary, prosecuted. Another mission of the State Bar focuses on strengthening diversity in the profession, addressing disparities in retention and advancement, and addressing equity and inclusion as part of its regulatory purpose. To this end, the State Bar conducted a first of its kind study on racial disparities in attorney discipline. The study was to determine whether there is a disproportionate representation of non-white attorneys in the discipline system. Male attorneys, as a result of this study, were found to be at a higher risk of receiving complaints and being disciplined than women. It was discovered that there is a disproportionate number of discipline cases against Black male attorneys, who were 3 times as likely to be placed on probation and almost 4 times as likely to be disbarred as compared with their white male counterparts. Now, the study also identified disparities between Hispanic and white and between Black and Hispanic females and their white counterparts, but the State Bar focused on the disparity between Black and white males as it was the largest disparity. The study found that the basis for discipline disparities were due to 1, the attorney's previous discipline history, which was found to have the strongest effect on discipline outcomes. The number of complaints received about an attorney was also considered. 3, the number of investigations opened as a result of those complaints. And 4, the percentage of investigations in which the attorney was represented by counsel. Black male attorneys have a lower likelihood of being represented by defense counsel during the investigation stage and during the State Bar disciplinary proceedings. Expanding on the above analysis, another study found that solo practitioners are more likely than attorneys in larger firms to be disciplined. Here, the State Bar found that the disproportionate impact on solo practitioners declines substantially when they're represented in the proceedings before the State Bar. But the statistics remain significant for the likelihood of an attorney as a solo being placed on probation. The State Bar continues to monitor disparities in the number of complaints filed by race, gender, and solo practice. It has a status, solo practice status, with aims of improving the equity of its attorney discipline processes. For instance, since the number of prior complaints is a strong predictor of discipline, in 2020, the State Bar archived nearly 400,000 cases of all types and origins that were more than 5 years old and were closed without discipline. This removes them from the view of the intake staff when they assess the merits of the new complaint. In response to low-level reportable action, such as bank matters, the OCTC will send out approximately 800 letters to attorneys regarding insufficient funds in client trust accounts. The letters will provide a comprehensive list of resources and warning language regarding the risk of discipline. By the way, the bank has an obligation under Business and Professions Code section 6091.1 to report instances of insufficient funds in the client trust accounts. I think the important takeaway here is that if you find yourself before the State Bar based on a complaint, you should hire an attorney to appear with you during the investigation stage and also during the State Bar discipline proceedings. Based on these studies and others, any attorney admitted after 2018 are required to complete 10 hours of MCLE training within the first year of admission on issues pertaining to ethics and law practice management. Content of those sessions should include or will include legal ethics, basic skills, substance abuse, and mental health issues, and recognition and elimination of bias in the legal profession. So with that said, how do we stay out of trouble? That's the question. We will begin the discussion with the rules of confidentiality presented by ADR Services Mediator, Ms. Hausner. Judge Ramona C. will discuss conflict of interest and the rules of professional conduct pertaining thereto, and we'll have a discussion about the duty of candor. Then we'll talk about unlawful discrimination and retaliation pursuant to Rule of Professional Conduct 8.41 and applicable Business and Professions Code sections, and conclude with the discussion about the psychology of mediation. So, Stacie, take it away.
All right. Well, good afternoon, everyone. Thank you for staying with us. I know it's been a long day for you all. So we really appreciate you being here with us. And thank you to Ramona and Barbara. I love working on this panel with you. It's been such a pleasure to be in your company. So I get the honor of talking to you all about confidentiality today. And this is an important topic because many lawyers come into a mediation and have conversations surrounding a mediation, assuming that everything said is going to be protected and private. And that's just not the case. Now, as mediators, we tell you everything in a mediation is confidential. And that's because we want to use information to help you fashion a good settlement for your client and get the other side to understand your perspective and try to shift both sides to more similarly evaluating the case. However, there are limitations to this doctrine in California. And so what I'd like to do is talk to you about some of the case law we have, what the statutes say, and then where we have some uncertainty so that you can best protect your client. So thank you for being with us here. I want to start by talking to you about California Evidence Code sections 1115 to 1123. These are essentially the confidentiality statutes in California. And basically, they say that anything said or written in a mediation is inadmissible in a non-criminal proceeding and is not subject to discovery. And this applies to mediators, to parties, and to their attorneys. And from a public policy perspective, the reason we have this statute is so that we encourage people to resolve their disputes informally. The Federal Rule of Evidence, Rule 408, has similar provision. It states that evidence of compromise offers and negotiations are inadmissible to prove validity and invalidity of a claim, or to impeach prior inconsistent statements in a civil proceeding. So it's a little more specific than California state courts will have. And it applies to impeachment as well, which, you can tell that the California statute is silent as to that. Now, please be aware that settlement conferences are not bound by the same confidentiality statutes as we have in mediation. So some people enter into a settlement conference assuming that their clients will be protected by this kind of blanket confidentiality. And that just doesn't seem to be the case in settlement conferences. Settlement conferences are carved out from these statutes, and Rule of Court 3.138 applies, as well as Evidence Code Section 1152. And Evidence Code 1152 says that evidence of a compromise or offer of compromise is inadmissible to prove liability for loss or damage. So we know that numbers exchanged during a settlement conference will be inadmissible. We don't know much about whether the communications themselves will be protected. So if you're giving information the other side does not yet know about, there's a question as to whether or not that will actually be inadmissible in your civil proceeding. So keep that in mind. Now, the federal law goes a little bit further, and there is a federal confidentiality statute at 5 USCA section 574. And it says a neutral and a party to a dispute resolution proceeding shall not voluntarily disclose a dispute resolution communication unless it is agreed to in writing, the communication is already public, the statute requires its disclosure, or it's needed to prevent an injustice, help establish a violation of the law, or needed for public safety. Now that's great. I love that because it says that communication will be held private. Now, lots of lawyers come into a mediation and they think that everything they say is private. That means that after the mediation, when it's over, that nobody can go out and talk to their neighbors about what happened or talk to the media about what happened or coworkers. And that just is not the case with California confidentiality statutes. They only apply to evidence in a civil proceeding. It does not make communications private. So I caution you lawyers in thinking that just because you're in a mediation, this information is now private. It is not. And so you have to be very careful with that. Now we'll talk at the end of this about ways to protect your client in this scenario. But keep in mind, it does not make all communications private in California. Be aware that us mediators, we do keep it private. We are bound by the model rules of professional conduct and ethics. And so when we leave a mediation, we cannot talk about what people said or identify who the parties are or what the settlement amounts are. So I teach at Pepperdine Law School, and if I do talk about a mediation that occurred, I do not use any identifying factors about names or numbers or anything that could allow for that. So don't worry about your mediators here. You're more worried about the opposing parties and whether they can share that with others. Now, a lot of you know that, and when you have an agreement, you put confidentiality provisions in your agreement. And so that's fantastic. But what happens if you don't settle? You still want these communications protected and what the offers are and demands are. So we'll talk about how to protect for that as well. So notice with me here what we do know from the California and federal statutes. We know mediation communications, both written and oral, are not confidential in criminal proceedings. They are not inadmissible. So I caution parties, if there's fraud allegations or a potential for a pending criminal investigation, be careful about your communications and the information you share, because those absolutely can come in criminal proceedings in California. So you want to be careful if you have any issues related to that with your clients. We also know with settlement agreements, they will be inadmissible unless you waive Evidence Code Section 1123. And this is very important because if somebody does not live up to their obligations under the agreement, you want to be able to enforce the agreement or set aside the agreement. So how do we waive a settlement agreement? That's important. The parties can agree in writing to waive it for enforceability. You can put in your settlement agreement what I think of as like magical language, such as this agreement is enforceable and binding, or it's admissible or subject to disclosure. That language in and of itself may be enough to allow the court to take a look at your settlement agreement. And settlement agreements also can be looked at in the situation of fraud, duress, or illegality. So keep that in mind with your settlement agreements. Also, it is important to understand when your mediation is finished, because no longer will confidentiality protections apply. So keep that in mind. You need to make sure if you think that this is protected, that you actually are protected and the mediation is ongoing. The ways to end the mediation is when you have a fully executed written agreement, it automatically ends. It ends when there is no communication with the mediator or any parties for 10 days. Then confidentiality no longer will offer protection. And it ends when there's an agreement by the parties to terminate the mediation. So in those situations, no longer do you have confidentiality. So if you're talking to your mediator and it's 10 days has passed, be careful there in terms of the confidentiality protections. Okay, so I know that's a lot. I want to talk to you briefly about limits to confidentiality so you don't accidentally expose your client to a harmful situation by making an assumption that is confidential when it's not. So remember what we talked about earlier, it does not apply in criminal proceedings, and there's no statute that makes this information private. So if your client has reputational concerns or has other pending litigation, they don't want any of this to come out, please be aware of that. Recently, we learned that confidentiality applies in a different civil proceeding. It does not just apply to your civil proceeding that's the subject of your mediation. And we learned that in this case, and amazingly, a confidentiality statute actually went up to the California Supreme Court. And that happened in a case called Concessions versus Superior Court. And this was several years ago. And an attorney's client sued them for malpractice for communications made during a mediation. And when it went to court, the lawyer said, I'm so sorry to hear that, but none of that can come in because it is confidential. And the trial court agreed with this argument and said the confidentiality statutes protect. Now, this case went all the way up to the Supreme Court, and the Supreme Court said, look, it is protected. The confidentiality statutes in California are very broad, and it would fall within the purview. And legislature, if you don't like this, it's your job to carve out this type of situation where a lawyer is using it to protect themselves rather than it having to deal with communications and resolution between the parties. So the mediation community all weighed in. Some really wanted no carve out because they like blanket strong protections of confidentiality. Others said, you know what, the confidentiality is not meant to protect lawyers from their clients and malpractice. In any event, the legislature in 2019 resolved this issue for us and found a compromise. And they put this in Evidence Code 1129C. And they required California attorneys to provide written disclosures to their clients explaining mediation confidentiality restrictions. So they need, lawyers, you now need, before you go into a mediation, and many of you know this already, but just keep it in mind, you need written acknowledgement from your clients that they understand the disclosures before participating, even in a mediation consultation, but also a mediation in any action other than class or representative actions. And they're very specific here at the legislature. They want the disclosure to be in the preferred language of the client, 12-point font on a single standalone document, and it has to be on a single page, and it must be signed and dated by both the attorney and the client. Now, if you don't do this, they don't think that that's enough to set aside a mediated agreement, but it will subject attorneys to discipline. So we're not exactly sure what will happen. We'll see as it goes, if it ever goes through the courts, but they think it's just an issue about attorney discipline. So make sure, lawyers, that you know this, that you can get this document signed by your client. Let's talk about other limitations, and I know we're limited on time, so I want to get through these real quickly with you. As I said, in California, we don't know if impeachment statements that you can bring in a mediation communication for impeachment. I think most trial judges would not allow it, but it's never been litigated and the statute's silent about it. So there is some uncertainty there. The confidentiality statutes also do not protect what I call the fruit of the poisonous tree. So let's say you're in a mediation and you reveal that you have an offshore bank account in the Bahamas. Now, it's clear that nobody can ask in discovery, didn't you say in the mediation you have an offshore bank account? That you can't do. But I do believe that they could then propound written discovery about all your offshore bank accounts, or in a deposition ask you to list your bank accounts, things like that. So I would say be very careful if you're not past your discovery cutoff. Talk to your mediator, let your mediator know that you have this issue. Us mediators, we are involved with information management. We know the importance of delivering information at an impactful time so that we can move people's evaluations of a case similar. And so talk to them about what you've shared, what you haven't, and if you're reluctant, maybe there's a best time to share it, if at all. We will hold any information private for you as well, so just be communicative with us about that. But be careful if you're not past your discovery cutoff, what you're revealing, because it can be discoverable. Also, another thing we don't know is the Tarasoff rule. What if in a mediation it's revealed that there's a plan to commit bodily harm or an ongoing crime? We don't know if the confidentiality statutes will protect that. It's not specifically carved out. It's never been addressed or litigated. So we don't know if a mediator or the other side can reveal that type of information in a civil proceeding. So be careful there. Now, one issue that comes up a lot now that we have these Zoom mediations, which are very efficient for everybody, is what state law applies. So all of us mediators can tell you we are mediating with people in different countries. I have people in different states in the mediation. And we don't know if Confidentiality will apply for the state where the communication is made. So if somebody's in New York and they make this statement, or if it's the state where the mediation's initiated, or if it's the state where the case is filed, we just don't know. This has never been litigated. And this could have an immense bearing on whether or not the information is admissible. So each state varies greatly. California, we just have this very broad blanket statement and we're really not sure how it applies. But a lot of other states are very specific and much less restrictive in terms of confidentiality. So let me give you an example. We know that at least 12 states have adopted what we call the Uniform Mediation Act. And this has a bunch of exceptions to confidentiality. So let me tell you some of the exceptions in other states. One is confidentiality doesn't apply if an agreement is signed by all the parties. So in California, we have to waive Section 1123 and make the agreement enforceable. Other states, it's just automatically going to be enforceable. They have an exception to confidentiality if the documents are required to be kept open to the public. So they're looking at public interest. They have exceptions for threats to commit bodily injury or violence, plans to conceal an ongoing crime. They have an exception to confidentiality if the information is needed by the mediator to defend like a malpractice claim against him or her. They have an exception to confidentiality for situations involving child abuse or neglect. They have exceptions if evidence is not otherwise available, or if the need for evidence outweighs the need to keep information confidential. And they also have an exception if the evidence offered in court involves felony or litigation over a contract reached in mediation. So notice the difference some states have with regard to confidentiality versus California. Now, I suspect, given we don't have much instruction, that it'll be up to the trial court judge to decide which confidentiality law will apply. But this can have bearing, and if you're revealing very sensitive information, please keep that in mind. All right, so as you see, there's a lot of confusion and what ifs and maybes with regard to confidentiality. I say, best practice, communicate with your mediator about the information and your concerns, hold information if you're really worried about the negative impact on your client's reputation or about a potential criminal investigation. The other thing, which I think is a great practice pointer, is to sign a confidentiality agreement with the other side. And before you even get to the mediation, you can collaborate and get an agreement with the other side. That makes you even more inclined when you get to the mediation to find settlement because you already have one agreement under your belt, but also it can protect you. So if you have a client and they have a bunch of litigation involving this, or they're concerned about their reputation, get an agreement that says all information exchanged in the mediation will remain private. That way you're protected. I know like in the Michael Jackson case, when the little boy was suing Michael Jackson, there were big reputational and criminal concerns. There was an ironclad confidentiality agreement that everyone signed before they even got there so that no one could talk about it. So if you are concerned, please consider doing these types of confidentiality agreements to give you that extra protection that the law may or may not give you. We just don't know. All right, well, thank you for your attention. I know that was a lot and I had to rush through it a little bit. If anyone wants to discuss it more, please do not hesitate to reach out to me. I love talking about it. Next up, we have Ramona C, and she will be talking about conflict of interest. So take it away, Ramona. Thank you.
Thank you so much, Stacie. As Stacie just mentioned, I will be talking about conflicts of interest, and that involves rules 1.7 and several other related rules. So what used to be Rule 3-300 is now divided into various rules concerning conflicts of interest, with current clients under Rule 1.7, former clients under Rule 1.9, and prospective clients under Rule 1.18. We will discuss each of these rules and how they interrelate. In addition, we'll also discuss Rule 1.0.1 subparagraph E, which concerns informed written consent, an absolute necessity in a conflict or potential conflict situation, and what actions you must take to ensure your client's rights to confidentialities of care, due diligence, and loyalty to your client. So what is a conflict of interest, and how does a conflict of interest arise? I will discuss rules about conflicts of interest and each of them in turn, but a conflict of interest can arise in several different ways. For instance, one way is you and your firm want to represent two clients who have been adverse in the past and are currently adverse in different matters. Another might occur when you hire a lateral associate or a partner who has worked for a company against whom you have a current lawsuit, and that lateral hire has certain company information that might be confidential or detrimental to that company if it ends up in your current client's hands. Yet another way is you plan to represent both the corporation and its employees, officers, and directors in the same lawsuit. Conflict issues usually arise in the form of a motion to disqualify brought by the opposing side in a lawsuit. You could also find it happens when you have to file a notice to withdraw, which you have your client sign after you've informed the client of a conflict that has arisen, and then you file it with the court. Now, if the client doesn't do that, then you may have to file a motion to withdraw, and if it's necessary and required under the rules, or in the unfortunate scenario after trial, when a new case is filed against the attorney for legal malpractice. Now, before I get into individual rules, I do want to note that the California rules of professional conduct do not create any new causes of action, and Rule 1.0, subparagraph B, subparagraph 3, specifically states just that. But oftentimes, violations of the rules will be brought up as part of the many alleged breaches of duty committed by the attorney in the underlying case or representation. So it can be additional fuel for the fire, so watch out. Now, as I mentioned, the California rules are now divided into separate and distinct rules, each dealing with a specific area of conflict of interest. So let's take each one in turn. With Rule 1.7, which deals with current clients, you are not allowed to represent a client that is directly adverse to or poses a significant risk that your representation would be materially limited by your responsibilities to another client. I think direct conflict is pretty easy to identify, but what does materially limited mean? In the context of multiple representations in the same lawsuit, as I mentioned, one common situation involves your representation of a corporation and its officers, directors, and managers. Your representation is materially limited if the best strategy for one of your clients is not necessarily the best strategy for one or more of the rest of your clients. In the mediation context, this might occur when the plaintiff is amenable to settling with one or more of your clients for the amounts offered during the mediation, but not as to others. This often happens because the plaintiff may be particularly upset by the treatment he or she received while employed, say, at the corporation, and blames a lot of his or her damages and troubles on the manager. In a 2020 case entitled Fregosa versus Eat Club, which will be in your materials, a motion to disqualify was filed by defense counsel in a wage and hour action where the plaintiff's counsel had previously represented several former employees of defendant's human resources department. Defense counsel argued that plaintiff's counsel received privileged documents in the representation of former HR employees, and the attorney would misuse them in the current action seeking to present evidence reflecting dishonesty and fault by these former HR employees, which the defense counsel argued was a direct conflict of interest. Superficially, this sounds pretty good, right? Pretty good argument. In the old days, this was often enough to prevail on a motion to disqualify, but courts now take a deeper dive into the issues. In fact, the trial court in Fregoso denied the motion, finding that the clients in both actions' interests were aligned, where plaintiffs were seeking to, quote, hold Eat Club accountable for the unlawful employment practice, end quote. The Court of Appeals affirmed, finding, quote, no direct adversity between plaintiffs in the two cases, and there was confirmation that the clients all gave their written informed consent to concurrent representation. The court also found against defendants on the issue of receipt of privileged communications, holding that plaintiff's counsel, quote, had not misused and would likely not misuse its knowledge of the privileged communications to gain an unfair advantage, end quote. As Fregoso illustrates, conflicts of interest arise most often due to former and current client conflicts of interest, and the courts are obligated to look at the specific circumstances involved before making a decision on disqualification. So let's turn to Rule 1.9, dealing with former clients. Rule 1.9a prohibits representation of another person or entity in the same or substantially related matter which is adverse to the former client without the former client's written consent. 1.9 subparagraph B prohibits a law firm from representing a person or entity in the same or a substantially related matter where a lateral lawyer's former firm represented a party with materially adverse interests, and the lateral lawyer has actual knowledge of confidential information. Finally, subparagraph C prohibits the use of confidential information obtained by a former client where such use could adversely affect the interests of that former client. In this regard, when hiring lateral attorneys, due diligence is required to avoid conflicts with your own firm's current or former clients. And I cite you to Oasis West Realty LLC versus Goldman, California Supreme Court case that is also in your materials. Finally, let's deal with Rule 1.18, which concerns prospective clients' conflict of interests. Rule 1.18 provides that attorneys may not reveal or use any information received by a potential client, even if no attorney-client relationship develops. Thus, that means the attorney must maintain the same duty of confidentiality with a potential client, even if he, she, or it never hires you. What is important to remember about this new rule and the new duty of confidentiality is that there is no time limit in the rule itself or in the comment. So you need to keep good notes of what was discussed with every potential client and keep really good records of those meetings. These records will be part of your due diligence in continuing to maintain this new required confidentiality and will serve as a reminder to you in the future of what transpired previously. One can only anticipate a meeting with a potential client where you were not hired, then 5 to 10 years later, another member of the firm, perhaps that wasn't even with the firm at the time, files a lawsuit against that same potential client, even possibly involving the same or similar issues from the opposite side of the fence. How would you even remember that 1 hour meeting 10 years ago? But the general counsel or CEO of that company may in fact remember you after you've already expended a lot of money and a lot of time towards the new lawsuit, and you may find yourselves in a disqualification scenario. So let's move away from the rules and address if there is a potential perceived or actual conflict, what can you and or your firm do? First, and obviously, you can withdraw from the representation, and oftentimes the client or clients will agree to sign a notice of withdrawal, which is then filed with the court. Sometimes, however, a client may not be willing to sign the withdrawal, even with a perceived conflict, which can occur if the withdrawal is sought close to a pending trial date. There is imminent discovery perhaps on the horizon, such as a client's deposition, written discovery responses are due, or a response or reply to a motion, such as a motion for summary judgment that's imminent. In other words, the client perceives that an additional conflict will be created or harm will be suffered if you leave them alone at a critical juncture in the litigation. And if you and your firm believe it is an irreconcilable conflict, then the next step is to file a motion to withdraw as counsel of record. And I'm going to refer you to Rule 1.16, which discusses withdrawal. Here, you'll be walking a very fine line between disclosing enough to convince the judge on your case to grant the motion, or saying too much and breaching the client's confidentiality and possibly hurting your client's position in the case. In such a situation, you should always ask for an in-camera hearing outside the presence of opposing counsel to discuss certain important attorney-client issues with the judge. This in-camera hearing will need to be conducted in all likelihood in judges' chambers. At least that's how I've always handled it when it was necessary. You should also hire a court reporter if you feel that it's something you need to preserve the record. And I think it's important just in case your soon-to-be former client gets mad enough that they file a subsequent malpractice action against you. And they're going to, if they say certain things were said or done, that in fact were not said or done, you need to protect yourself. Now, your client will also be given a chance to speak to the judge, also in chambers. So that I think is something that you have to be ready for. If the court is convinced that withdrawal is required, then the judge will usually craft the ruling so as to afford your client additional time to obtain new counsel and to provide enough time to new counsel to prepare for trial or prepare for pending motions, discovery, usually with a series of continuances. Now, if you're too close to trial, then you know the burden is going to be that much higher because it is not just prejudice to your client, but the court's going to be looking at also prejudice to the other side. How many prior continuances were there? Was it your side that asked for the other continuances? Was it the opposing counsel, or did the court continue the trial date due to calendar congestion or because it was already engaged? Make sure you remind the court how other continuances were obtained, especially if it wasn't at your request, because then it's less prejudice to the other side if they were the ones who had asked for several continuances in the past. But the court will most likely inquire as to why you waited so long to seek withdrawal if it's too close to the trial date. I can't guarantee that all courts will grant motions to withdraw at the last minute because I know several judges who sometimes don't do it, but I believe that most will. One other point I would like to make at this juncture is that under Rule 1.10, it provides that a proper screen can be used to avoid the knowledge of confidential information by, say, a lateral attorney coming from another firm to being imputed to the new firm, where that new attorney was not substantially involved in the prior firm's matter before joining the new firm. Of course, the new firm must immediately inform the client of the screen and provide detailed information to the client in order to obtain informed written consent. This is a change from the pre-November 2018 rules, which imputed an attorney's knowledge to the entire firm. And when I speak of a screen, it's defined in Rule 1.0.1K as the, quote, isolation of an attorney from any participation in a matter, including the timely imposition of procedures within a law firm that are adequate under the circumstances, one, to protect information that the isolated lawyer is obligated to protect under these rules or other law, and two, to protect against other law firm lawyers and non-lawyer personnel communicating with the lawyer with respect to the matter, end quote. But in most instances of conflict of interest, I believe you and your firm would rather continue with the representation if that is at all possible under the rules. So how do you accomplish that? So let's turn to informed consent and informed written consent, since the rules we've already been mentioning have that requirement front and center. Under Rule 1.0.1, both terms are defined, and under subparagraph E, informed consent means a person's agreement to a proposed course of conduct after the lawyer has communicated and explained, one, the relevant circumstances, and two, the material risks, including any actual or reasonably foreseeable adverse consequences of the proposed course of conduct. Under subparagraph E1, informed written consent means that the disclosures and the consent required by paragraph E must be in writing. Under subparagraph N, a writing has the meaning stated in Evidence Code section 250. A signed writing includes an electronic sound, symbol, or process attached to or logically associated with a writing and executed, inserted, or adopted by or at the direction of a person with the intent to sign the writing. So does the informed written consent completely shield you and your firm? That will almost entirely depend on what is in the document. Your informed written consent must contain all material facts and issues so that you have completely informed your client of the conflict or potential conflict. If the informed written consent document is too vague or does not mention a particular fact or issue at all, then the court may find that the informed written consent required by the rules was not in fact obtained and that such document is void. In the Shepard, Mullen, Richter, and Hampton versus JM Manufacturing Company case, the California Supreme Court from 2018, also in your materials, the court held that the firm's former representation of a city was in fact sporadic and restarted on an employment matter only 2 weeks after being hired by JM on a key TAM case against the city, and that this was a clear conflict of interest, even though the two cases were different. The court found that since the firm did not disclose its prior representation of the city at the time it was hired and did not inform the city, the consent was not fully informed and therefore was invalid. This sort of conflict can occur and does occur quite regularly. A firm the size of Shepard, Mullen, and others with offices not only around the state of California, but perhaps in any number of other states or even internationally, will have to be ever diligent to avoid running afoul of the rules regarding conflicts with prior clients, current clients, and future clients. And this is not just with litigation, which is what we've been focusing on here. What about your project finance department in Riyadh or your government contracts department in Beijing? There could be major public and/or public contracts, business deals that could cost your firm potentially millions of dollars if suddenly there is a conflict that was not previously discovered and was not disclosed. So many firms have a lot of staff devoted to this issue, and I think for really good reason. What about future potential conflicts? Can part of the informed written consent? The short answer is yes. In the comment to Rule 1.7, I think is very instructive here. Number 9 provides, this rule does not preclude an informed written consent to a future conflict in compliance with the applicable case law. The effectiveness of an advanced consent is generally determined by the extent to which the client reasonably understands the material risks that the consent entails. The more comprehensive the explanation of the types of future representations that might arise and the actual and reasonably foreseeable adverse consequences to the client of those representations, the greater the likelihood that the client will have the requisite understanding. The experience and sophistication of the client giving consent, as well as whether the client is independently represented in connection with giving consent, are also relevant in determining whether the client reasonably understands the risks involved in giving consent. An advanced consent cannot be effective if the circumstances that materialize in the future make the conflict non-consentable under paragraph D. A lawyer who obtains from a client an advanced consent that complies with this rule will have all the duties of a lawyer to that client, except as expressly limited by the consent. But consent by itself is insufficient, where even if you have provided all of the information necessary to protect your clients and your firm and you, if the representation will prevent you from competently representing all of your clients. And I refer you to Clem versus Superior Court, Court of Appeals case from 1977. Obviously, Clem is an old case. Many of you weren't even born yet, let alone practicing law, but it is still good law. Clem involved the dual representation of both a husband and wife in a contested hearing on child custody where both parents were opposed to the government's claim for child support. There, the court did not disqualify the attorney, but held, quote, as a matter of law, a purported consent to dual representation of litigants with adverse interests at a contested hearing would be neither intelligent nor informed. Such representation would be per se inconsistent with the adversary position of an attorney in litigation, and common sense dictates that it would be unthinkable to permit an attorney to assume a position at a trial or a hearing where he could not advocate the interests of one client without adversely injuring those of the other, end quote. In the comment section to Rule 1.7 at number 6, it states informed written consent may be required, however, if there is a significant risk that one, the lawyer may temper the lawyer's advocacy on behalf of one client out of concern of creating precedent adverse to the interests of another client, or two, the lawyer's action on behalf of one client will materially limit the lawyer's effectiveness in representing another client in a different case. For example, when a decision favoring one client will create a precedent likely to seriously weaken the position taken on behalf of the other client. Factors relevant in determining whether the client's informed written consent is required include the courts and jurisdictions where the different cases are pending, whether a ruling in one case would have a precedential effect on the other, whether the legal question is substantive or procedural, the temporal relationship between the matters, the significance of the legal question to the immediate and long-term interests of the clients involved, and the client's reasonable expectations in retaining the lawyer. The courts have also found that it would be impossible for an attorney to obtain informed written consent where the attorney represents a closely held corporation and its officers and directors, stating, quote, where the only shareholders of the corporation are also directors involved in the controversy, to allow the shareholders to consent on behalf of the corporation would render the rule meaningless, end quote. And that is a citation from Forrest versus Baeza, a 1997 case. It's a CalApp case, also in your materials. Finally, even though you obtain written informed consent, circumstances may present themselves that will require you to make further disclosures of potential conflicts and to obtain further written informed consent from the client or clients. The comment to Rule 1.7 provides in paragraph 10, a material change in circumstances relevant to application of this rule may trigger a requirement to make new disclosures and, where applicable, obtain new informed written consents. In the absence of such consents, depending on the circumstances, the lawyer may have the option to withdraw from one or more of the representations in order to avoid the conflict. Now, under the comment to the same rule at number 2, paragraphs A and B apply to all types of legal representations, including the concurrent representation of multiple parties in litigation or in a single transaction, or in some other common enterprise or legal relationship. Examples of the latter include the formation of a partnership for several partners or a corporation for several shareholders, the preparation of a prenuptial agreement, or joint or reciprocal wills for a husband and wife, or the resolution of an uncontested marital dissolution. If a lawyer initially represents multiple clients with the informed written consent as required under paragraph B, and circumstances later develop, indicating that direct adversity exists between the clients, the lawyer must obtain further informed written consent of the clients under paragraph A. So your duty to obtain further informed written consents from your client is an ongoing duty, even long after representation occurs, as I mentioned, with former clients under Rule 1.9. And of course, there are situations where even an informed written consent cannot solve a conflict of interest and you cannot represent the client. And I cite you to Clem and to Woods versus Superior Court, a 1983 case. All right, so at this time, I'd like to turn to a different rule section, Rule 3.3, dealing with duty of candor to a tribunal. Ms. Hausner and I will be addressing Rule 3.3 and issues regarding violations in the mediation context and before the court. 3.3 forbids attorneys from engaging or assisting in dishonest conduct, making false statements of material fact or law to a tribunal, and offering evidence the lawyer knows is false. The rule specifically requires that a lawyer who knows a witness has lied, quote, take reasonable remedial measures, including, if necessary, disclosure to the tribunal, end quote. A false statement of law includes citing to cases that are overruled or statutes that are repealed or previously found to be unconstitutional. And I cite you to the comment to Rule 3.3 at number 2. The comment at number 4 advises that, quote, if a lawyer knows that a client intends to testify falsely or wants the lawyer to introduce false evidence, the lawyer should seek to persuade the client that the evidence should not be offered, and if unsuccessful, must refuse to offer the false evidence, end quote. Just as an aside, what if you have a client whom you know is lying? A lying witness often creates a conflict of interest between an attorney's ethical duties to the court and his or her ethical duties to the client. And what can you do about it? An attorney can refuse to offer the witness's testimony. You could correct the perjured testimony. You could even withdraw from the representation. But as you can already tell, and if you're thinking about it, such actions are only could possibly damage a client's case and go directly against what the client's interests are and what their instructions are to you. But a further detailed discussion of this topic will have to take place for another day. Let me just say that a tribunal is defined as Rule 1.0.1 subparagraph M as a court, an arbitrator, an administrative law judge, or an administrative body acting in an adjudicative capacity and authorized to make a decision that can be binding on the parties involved, or two, a special master or other person to whom a court refers one or more issues and whose decision or recommendation can be binding on the parties if approved by the court. In the litigation context and representations, or rather misrepresentations made to the court, there are several instances where this arises. In the discovery context, oftentimes counsel will state something in a declaration, which is contradicted by opposing counsel. The most common I think of is the meet and confer process, right? Either counsel disagree on what was said during the meet and confer process, or they disagree on whether the meet and confer process really occurred or whether it was even meaningful. What I think is important in these situations is to document your dealings with opposing counsel in your meet and confer attempts. If you called several times and left detailed messages and opposing counsel did not call you back, you can imagine, and this has probably happened to everyone, later on, there's a motion to compel, and the attorney says, you never made any attempts to contact me. The motion to compel should be denied because you didn't meet the threshold requirement of the meet and confer. I think you should have confirming letters or emails detailing what you did do to protect yourself and your client. And let me say this, counsel have often said to me when I was a trial judge, we had such a great working relationship at the beginning of the case. I didn't think I'd needed to write emails or confirming letters. Well, what can I say? Things can change on a dime. You are advocates. And, so protect yourself and your client. You can write an email or a confirming letter saying, hey, I called you a couple of days ago. I left you a message about your answers to my January 5th specials. Just as a reminder, here are the problems I have, and I'd like to discuss it with you. Something, like that covers all of the points you want to make. Why is this important? For most judges, it will otherwise be he said, she said, he said, she said, she said. You get what I'm saying. Basically, they're looking at two people, sometimes saying, the opposite thing. It's like a traffic accident. The light was red. No, the light was green. So, and if you believe, for instance, the judge knows you well enough because you've appeared there several times to know that you would never lie, then I put it to you that the judge should not be presiding over your case and should probably recuse him or herself. Right? Because they shouldn't have that sort of feeling that they're already biased in that way. So documentation assists the court in understanding the attempts you made and where the problem lies. Now, if your opposing counsel sends you a confirming letter that seems to confirm matters that did not occur at all, you send a response letter indicating what in fact did occur right away. And then, of course, the court will look at both sides in the papers and make a decision. But don't leave a false representation in a confirming letter go, because it will be argued at the time of the hearing or even in the reply brief that, or opposition, that it wasn't true, or that if it wasn't true, that you would have responded and said so. So it's sort of a confirmation by omission. Also, where sanctions are usually requested on a motion to compel, the court is much more likely to award sanctions where the documentation demonstrates that one of the attorney's conduct caused the dispute to escalate, requiring the filing of a motion. And then that may support the sanctions that you want. Another instance where candor is often tested is with a summary judgment motion. One sees this quite often where the opposing side uses the other side's party's deposition testimony. And then later in the opposition to the motion, there's a supporting declaration by the client that often says the opposite to try to raise a triable issue of fact. Well, as you know, most of you probably, there are many, many cases that hold that you cannot raise a triable issue of material fact through your own conflicting testimony. So what is the sanction for this sort of conduct? Well, if that particular issue that the deposition and declaration went to is the only part of the motion for summary judgment and the motion is granted, then the question is, can counsel seek a motion for monetary sanctions afterwards? Sure, you can always seek sanctions, but most courts are probably not going to award monetary sanctions for that conduct, especially if you won the motion, because the case will be dismissed if that was the sole cause of action, which quite frankly is the ultimate sanction, right? So how about counsel making misrepresentations during a hearing or during trial? Again, if it is something that can be documented, do it. and then present it to the court. If you think that opposing counsel will attempt it during a hearing or trial, have your documentation at the ready so the court can make a ruling on the spot if it is a verbal motion to strike. If you know ahead of time that this may become an issue at trial, then a motion in limine should be filed so that the jury never hears about it. If counsel violates a ruling on a motion in limine, you can ask at a minimum for a ruling to strike the offending testimony and for the jury to disregard it. You know the jury instruction for an admonishment in front of the jury if it happens more than once, or if it is so egregious and inflammatory that no reasonable jury could disregard it, make a motion for mistrial. It seems like, oh, who wants to file a motion for mistrial? Well, I had to grant a motion for mistrial on a case on the last witness, on what was supposed to be the last day of testimony, because the violation of my ruling on a motion in limine was so egregious that there was no way that the jury was going to be able to ignore it. So it does happen. So let me turn to Stacie now, because I think she would like to make a few comments about candor and how it affects the mediation process. Stacie?
Yeah, I appreciate that. I do want to say a few things about truthfulness in mediation. And obviously, mediation is not a tribunal as it is defined, because we are not decision makers here. We are messengers. But lawyers tend to get really upset sometimes when the other side is lying or being less than truthful at a mediation. And so I just wanted to jump in real quickly on this. I tell lawyers, don't worry about it. Us mediators, we're neutral, impartial, unbiased. That means we have no stake in the outcome. We are not decision makers, we are messengers. And our job is to get you to understand what their narrative will be like should you go to trial. And so we're going to communicate what they're saying to us. If it is not true, you can tell us so that we have information to push back with. Sometimes the lawyer doesn't know it's untrue. And so giving us information and arming us with a pushback to their positions, or it can be very good in getting their attorney to reevaluate the case, but also to get them to. So in a mediation, we do not need everybody to believe the same way or to hold the same truths. In fact, it's very common that they don't, that there's two different perspectives here and there's two different truths. It is not an obstacle to settlement. You know, what you're doing in there is you're listening to the evidence that they're going to be using. You're planning how you're going to respond to that, both at trial and giving the mediator information to push back because you're trying to change their perspective. What we can do is with these different truths, we can still move to solution-focused remedies. So I really don't think that lawyers need to be concerned about this. No one's going to get us on their side by lying. We take our neutrality very, very seriously. Please know that as mediators, we will not purposefully lie. If somebody came to us and said, look, I have insurance, but I told them I didn't. So tell them we don't have insurance. We're not going to do that. That would be unethical for us to purposefully carry a lie. But if they're telling us information, we are going to try to share with you what they're telling us when we don't know it's a lie, and then bring it back to you. For a practice pointer, I like to tell you what I think can be protective if you as counsel are relying on a representation made by the other party. And you are taking, let's say, significantly less money because you believe, let's say, that they don't have insurance. And though you'd normally be seeking $1 million settlement, but they have no insurance, so you're willing to settle at $100,000. What I would recommend attorneys do to protect their clients is to put this in the document, in the settlement agreement, and put it in the form of a recital. So you can say, whereas defendant represents that they have no insurance, plaintiff is willing to take $100,000. That way, if it comes to bear that this is untruthful and you get information to the contrary, it is now within this settlement agreement for the judge to take a look at and set aside the agreement or whatever you want the result to be. If you're relying just on an oral mediation communication and you say, look, in the mediation, the other side said they have no insurance, that might not come in. That may have no bearing on the enforceability of your agreement. So I tell lawyers when they're concerned, or if they're relying heavily upon a representation by the other party, the best practice pointer is to make sure you get that language into your settlement agreements. So that's all I have to say, just very briefly. In order to protect your clients, that's what you can do if you think that the other side's lying in a mediation. All right, so now I get the pleasure of telling you that Barbara is going to now talk to us all about Rule 8.4.1. So take it away, Barbara.
Thank you, Stacie. We're going to be talking about California Rules of Conduct, Professional Conduct, rules in Rule 8.41. And I'm sure, as in the information that went out, it indicated it's not so new rule. It is not a new rule. It's been going on since 2018. I'm trying to get my timer, my phone to get the timer on so I won't go over. But it is a rule, and it is a restatement of Rule 2-400. It's as of November 2018. And the old rule related to mere discrimination. The old rule prohibited discrimination as conduct in the management of a law practice. And a law practice included sole practitioners, law partnerships, law corporations, corporate and government legal departments, and other entities which employ members of the bar. So it required a tribunal of competent jurisdiction to first determine unlawful conduct. So even before it came before the state bar, it had to have gone civilly or criminally for someone to determine that unlawful conduct had occurred, or it had to have been decided before a disciplinary investigation of an agency or initiated by the state bar, before it could be initiated by the state bar. Then, if the finding of unlawfulness was appealed and not upheld on appeal, then no discipline could be imposed. So the old rule provided a limited protected class also, and the new rule expands not only the prohibitions in the area of discrimination, but it also prohibits harassment and retaliation. The new rule also broadens the protected characteristics found in the old Rule 2-400B. So let's talk about 8.41. We're not going to go word by word of it because it's just too much to do, but we're just going to talk about the substantive changes that have been made. The first is that the new rule expands the rule to prohibit unlawful discrimination or unlawful discriminatory or harassing conduct generally in the course of representing a client. The rule expands new 8.41 expands the rule to prohibit unlawful discriminatory or harassing conduct on the basis of protected characteristics beyond those that were referenced in the current rule. We'll talk about what those were in a minute. Third, 8.4.1 expands the rule to prohibit unlawful retaliation. Fourth, it expands the rule by eliminating the requirement that there be a final civil determination of wrongful discrimination before disciplinary investigation can commence or discipline can be imposed. I just talked about that a minute. This change with the new rule, I'll call the new rule and the old rule, but for expediency's sake, this change would give the OCTC original jurisdiction to investigate and prosecute any claim of discrimination that is described as coming within the scope of this new rule under the current procedures of the disciplinary system. This point was the most hotly contested in the change of the rule, whether or not the state bar had original jurisdiction or whether or not a person who has filed a complaint against them couldn't be prosecuted by the state bar until a finding by a civil or criminal or some other type of legislative agency or licensing agency had made a determination before the state bar could get its hot little hands on them. At any rate, this led to a requirement for self-reporting, and we're going to talk about a little bit about the many, just in doing research, the requirements for self-reporting. Then fifth, this new rule requires a lawyer who has been charged with or is being investigated for a violation of the rule to give a notice, not only to the state bar, but to the Department of Fair Employment and Housing, to the U.S. Department of Justice, or to the U.S. Equal Employment Opportunity Commission, depending on the rule disciplinary charges that have been filed. So we'll talk about the more, as I said, self-reporting rules later. So if we go and talk about the various broad topics, we'll start with the title. First, 2-400, the old rule, used to say that prohibited discriminatory conduct in a law practice. The new rule doesn't limit it to law practices. It prohibits discrimination, harassment, and retaliation, period. It doesn't necessarily define who it is a law practice. Whether the alleged discrimination happens in representing a client, including conduct before a judicial officer, Stacie and Ramona just talked about that a bit, or in terminating or refusing to accept the representation of any client, or in the law firm's operation, a lawyer shall not harass or discriminate against persons of any protected characteristic or unlawfully retaliate against such persons. The rule applies now not to just managers of a law firm. In other words, the bosses aren't only ones that are going to be liable if there's some discrimination or retaliation or harassment going on, but all law firm attorneys or lawyers, and even to non-lawyer personnel, can be responsible and held responsible. All have the responsibility to advocate, and this is what is required, to advocate corrective action to address known harassing or discriminatory conduct by the firm or any of its other lawyers. So you say, who are the other lawyers not in the firm? Well, those lawyers that are of counsel, for instance, or contracted outside the law firm. If it deals with those discriminatory, if there's some discrimination in the quote law firm or those associated with the law firm, then the rule applies. One lawyer cannot knowingly assist, solicit, or induce another to violate the rule. Moreover, the discrimination can be against an employee, an intern, a volunteer, or a person providing services pursuant to a contract. So we have to really be careful about this new rule because it's very broad in terms of what used to be just within the law firm confines. A firm or law firm is defined as practitioners who share office space and occasionally consult or assist each other. Ordinarily would not be regarded as constituting a law firm. You can find these comments in the comments to the rule. However, if they present themselves to the public in a way that suggests that they are a law firm or conduct themselves as a law firm, they may be regarded as a law firm for purposes of these rules. The terms of any formal agreement between associated lawyers are relevant in determining whether they are a firm, as is the fact that they have mutual access to information concerning the clients they serve. Law firm management, by the way, and supervising lawyers retain their separate responsibility under rules 5.1 and 5.3, in addition to 8.4.1, because they are in management under 5.1 and 5.3. So they still have certain responsibilities. And they are also bound, as I said, by 8.4.1 as it relates to supervisors and management. Rule 8. The new rule, and in fact, no rule, imposes on the alleged victim of any conduct prohibited by these rules any responsibility to advocate corrective action. So the victim, alleged victim, doesn't have to try to correct the action. It's incumbent upon the persons who know of it or who have control of the person who knows of it to authorize corrective action and to perform corrective action in these situations. The rule includes the conduct of a lawyer in a proceeding before a judicial officer. A lawyer may refer to a particular status or group only when the reference is relevant to factual or legal issues or arguments in the representation. This particular comment goes to the broad characteristics that are now included in harassment. It's not just gender, it's not just race, it's a lot of things that have been listed, including religion or identity or things like that. So if this is the case, then the question can be asked, what about voir dire and peremptory challenges? How are we going to avoid discriminating against those jurors or those that you're questioning? Well, a court's finding that peremptory challenges were exercised on a discriminatory basis does not alone establish a violation of paragraph A. So there has to be other things associated with that when we're talking about peremptory challenges. And then, can a lawyer limit his practice to members of underserved population? And the rule provides that yes, a lawyer can also restrict who she will accept as clients for advocacy-based reasons as required or permitted by rules of other law. In other words, of course, you can't discriminate against, let's say, mentally disabled or physically disabled persons. But if your practice centers on that, then you can, in fact, concentrate your practice on those groups of people. And what about the First Amendment? Well, the First Amendment does not apply, nor does the Constitution, Article 1, Section 2 to this rule. This rule doesn't apply to that particular issue when we're talking about First Amendment rights. You will note that the protected characteristic category has expanded. Other than race, sex, age, national origin, or sexual orientation, the protected characteristics include religious creed, color ancestry, physical disability, mental disability, as I stated, medical condition, genetic information, marital status, gender identity, gender expression, military and veteran status, and the catch-all phrase, other category of discrimination prohibited by applicable law. So whether the character, and this is whether the category is actual or perceived. To unlawfully retaliate, as defined in C4 of the rule, means to take adverse action against a person because that person has opposed or pursued, participated in, or assisted any action alleging any conduct prohibited by the paragraphs of this rule. So the rule used to be just you can't discriminate. Now the rule is you can't discriminate, you can't harass, you can't retaliate. I'm pretty sure along the lines they're going to come up with another category, but that is as it stands today. Perhaps the biggest change to the rule, and by the way, I'm assuming that we all understand that the rules of professional conduct says in 8.4, you can't participate in this kind of conduct anyway, but 8.41 kind of defines it. The biggest challenge to this rule is that the office of the Chief Trial Counsel of the State Bar is not prohibited from investigating or initiating discipline against a member even before a civil or criminal action has been filed and adjudicated against that member. So the old rule required that a tribunal of competent jurisdiction will have the first adjudicated, should have first adjudicated a complaint against the member alleging discrimination, and then found the unlawful conduct occurred. In order for discipline to be imposed under the old rule, however, the finding of unlawfulness must be upheld, and then it didn't become final until after appeal. So needless to say, there were very, very, very few, if any, that we could find. And in fact, the comment says that, that brought the state bar into play if there was another tribunal that had to proceed, because not only could it go extended until the appeal, but after the appeal was final, if the tribunal had found adjudicated and then the appeal, the state bar still couldn't get it until the appeal was final. So the new rule permits the imposition of discipline for conduct that would not necessarily result, not even necessarily result in the award of remedy in a civil or administrative proceeding if the proceedings were filed. So the takeaway is that the state bar now has a means of prosecuting and investigating cases without waiting years in some cases before somebody else finishes its investigation. Other than the rule requiring the attorney to notify the state bar of any criminal or civil or administrative agency action premised on the conduct of violating the rule, that is harassment, retaliation, and discrimination, there are other rules required and must be followed. And those mostly are found in the Business and Professions Code, as it requires several self-reporting requirements. And so if you want to get in trouble, we're talking about avoiding state bar hearings and appearing before the state bar, you might want to not only review the rules of professional conduct, but also review the Business and Profession Code for self-reporting, because if you don't self-report, you can likely also come before the state bar. For instance, the Business and Professions Code section 6068, subdivision O, requires attorneys to notify. When they say notify, they mean self-report, not you're totally responsible for your actions, to the state bar and any other appropriate agency of the following. One, for instance, if they've been disciplined in another jurisdiction or any licensing agency, you have to tell the state bar, you have to report. Even if it's in Nevada, if you've been disciplined there, and you practice and you're licensed in California, you have to tell California that you've been disciplined. Two, an entry of judgment of civil action for fraud, misrepresentation, breach of fiduciary duty, or gross negligence committed in a professional capacity. So if someone has sued you and you've been, there's been an entry of judgment, you have to tell the state bar. You have to self-report an imposition of judicial sanctions of $1,000 or more. Most of us know that because either judge, you try not to get the judge to impose sanctions of over $1,000 because you don't want to have the judge report and you also report. So we know that rule pretty much. We also know the rule that if you have any felony convictions or indictment or information and certain misdemeanor convictions, if you have those as specified in the statute, you also have to self-report that to the state bar. And then the reversal of a judgment and proceeding for professional misconduct, gross or incompetence, or willful misrepresentation. There's a reversal of a judgment. You have to tell the state bar that too. You have to report it. So those are the items in which self-reporting has become important, and self-reporting is also reporting in this new rule about discrimination and harassment and retaliation. One that I found out that I was very interesting was that if you have had 3 or more lawsuits dealing with malpractice issues filed against you, not convicted, but filed against you in a 12-month period, you have to report it to the state bar. So they, if they wish to, can investigate the cases against you. And then lastly, just of a sample, should one choose not to acquire professional liability insurance and then find yourself having violated any of the sections, including the Business and Professions Code sections, you have to self-report to the state bar the occurrences listed, and you have to self-report that within 30 days. So these are things that catch you unaware sometimes, and I'm talking about attorneys because some things I didn't recognize, but maybe because the vast majority of us will never see a letter from the state bar. But just in case, you should be, we, as I'm no longer a judge, we should be aware of the requirements that are required, the requirements to not have to go before the state bar. And all these state bar reporting requirements are listed at the state bar website, as well as all the rules are listed at the state bar website, as well as the comments to the rules. They're all on the state bar website, as well as earlier, the studies that we referred to that the state bar performed and all the statistics that the State Bar has on us is all on their website. So ignorance cannot be a defense. And so thank you for that. Stacie.
All right. Well, thank you so much, Barbara. We now wanted to shift our focus to talk about behavior of litigators in a mediation. And we feel like this fits into the ethics conversation because it relates to attorney behavior in litigation. Mediation is such a big part of it. And so what we want to discuss is in this remaining time, and you are at your last half hour of a very long day, so thank you for staying with us. But we want to talk to lawyers about how they can optimize their outcomes in the mediation just simply because of their behavior. And the first concept we want to discuss with you is basically civility. We believe that by acting respectfully and likable in litigation, it's going to optimize your client's outcomes in the litigation. Now, keep in mind, 95% of all cases settle. That means that most of you will be in a mediation or in some sort of settlement discussions as a means to resolving your dispute. And there is this concept called likability. There is a man by the name of Robert Cialdini. He is a very well-known social scientist, behavioral economist, who gives insights on how people can get others to give them what they want, how to get people to act in ways that they ordinarily wouldn't act in. And one of the main concepts he talks about is likability. Now, he did these studies a long time ago with Tupperware salespeople, and he found that people bought more Tupperware from the saleswomen that they liked. This type of experiment has been replicated in many different concepts, and the result holds true, which is people that are likable, relatable, people that they respect, people who give more to them. So given that 95% of your cases are going to settle, let's get the other side to like us. Now, your clients are already in major discord because if they have a conflict that's risen to the level of litigation, they really don't like the other side and are upset. And you can bridge this gap by acting respectfully with opposing counsel. Now, what I always recommend when I do these MCLE or bar MCLEs in law firms or to bar associations is let's extend like general courtesies to the other side. Let's work with them on calendaring, grant discovery extensions if it won't compromise your client's case. I even suggest if you're headed out for a protracted litigation, asking the other side to grab coffee, maybe after your status conference, but develop a good working relationship with the other side. I see it all the time in mediation when the attorneys get along. I've even been in a mediation where I've heard counsel tell their client, look, the other lawyer is really smart and respectable. I really like him. If he's evaluating the case this way, then this must be an accurate evaluation, and accepted the settlement proposal on that ground. So I see it a lot, the impact of getting the other side to like you. I know the concept's very simple, but I see the impact of it. Now, the thing that I want to say is that when us mediators aren't there, it's important that you engage in good negotiating behavior. And one of that, in order to create this likability, one thing you want to do is appreciate concessions. Now, us mediators, we do that when we have you in separate rooms. We have you in different rooms. They're called breakout rooms when we're doing them virtually, or you're in our offices, conference room, in the conference rooms. In Southern California, lawyers tend to want to be in separate meetings the whole time. The formal word for this is caucus, and the mediators, we engage in what we call shuttle diplomacy. We convey messages back and forth, trying to get both sides to understand each other, to get information pertinent to make a decision, to try to shift perspectives and get evaluations more similar. When we're doing this, we are reframing. We are taking out toxicity and making communications productive. We're also appreciating concessions. So if the defendant's working hard to try to give something to get the case settled, we're very appreciative. Thank you so much for doing this. If you don't have a mediator doing that for you and you're engaged in settlement conferences, settlement discussions without a neutral, please appreciate when they're working hard to get this done. If you're acting collaboratively, it's going to get you much more than if you approach a mediation like a gladiator. So we're taught that in law school, and in court, we often fight for our clients and discount everything. But we are going to do much better for our client if we say, oh, that's a good point. Unfortunately, I can't get you this, but maybe I can get you that. And show them that you're working to find a solution and you're appreciating the work that they do. This will go a very long way for you in getting an optimal outcome for your client. This also ties into this rule of reciprocity, and Robert Cialdini talks about this too. He wrote this book, Science of Influence, and that is one of the other concepts. And the rule of reciprocity says, basically, we have a strong social obligation to repay a favor with a favor of equal or greater value. So when we get invited to someone's house for dinner, we often bring a gift or reciprocate the invitation. They've done studies where they look at charities who give something free, like a little 5-cent flower. People are more inclined to make a donation of much greater value than that. Now, I bring this up because if you're engaging in respectful, likable behavior, you are often going to have that reciprocated. Now, it's not always, because we all have nightmare stories about opposing counsel. That's very difficult. Us mediators, we can help you with that. But without us there, if you're engaging in positive negotiating behavior, you are likely to get that reciprocated. If you are engaging in generous negotiating behavior, you're likely to get that reciprocated. So if you are coming into a mediation and you are coming in taking a backward step, and you are offering less than your 998, or you're offering less than your last offer that they didn't accept, you are going to upset the other side. Now, I'm not saying the situation hasn't changed, and maybe there's reasons to do that, and there's could be good strategy in terms of setting expectations. But I do want you always to consider that that insults the other side. That makes them want to engage in negative negotiating behavior. You are trying to get the most you can from them. So how do you do that? You give them the impression that you are being generous and working hard to make concessions and collaborate also. So I think that we want to be careful. I remind people in mediations that the other side needs to feel like they're getting a good deal too. They need to feel there's a gain to deciding to accept a settlement rather than pursuing litigation. And they need to justify this to their coworkers or to their spouses or to their supervisors or to their clients. So instead of fighting and being antagonistic with, I'm going to destroy you at trial, spend that energy convincing them why this deal is a good deal for them. Help them understand how this is a gain for them, how they can sell it. So one other thing with negotiating behavior and making your negotiating behavior likable and most impactful is this initial number. We call this an anchoring number. There is a cognitive bias called the anchoring bias that has to do with people assess value based on earlier numbers given. So if you go into a camera store and the sign says camera, $1,000 on sale for $500, you are going to be more inclined to buy that camera than another camera that says $500, because you're looking at that as a good deal in relation to the $1,000 price. Lots of marketers know this, lots of attorneys know this. And when they come in with their opening number in a negotiation, they say, look, I'm going to come in, I want to set the expectation that this is going to be high, that this is a 6-figure negotiation. So I'm going to start at $1 million. And I know the mediator is going to ask me to make concessions, so I want to give room to move. And I also want them at the end of the day, if I want to settle at $200,000, to look at that number in relation to my starting number, which was $1 million. Now, that is a very sound theory. This is true. People do look at numbers that way. And so I respect the strategy. I'm all for it. But I do like to caution people that you want to find the sweet spot. You don't want to pick an opening number that is so extreme and not related in any way to damages or the validity and risks and costs of the case. Because if you're too extreme, you insult the other side. now we have this problem of not being likable. We get in this reciprocal negative negotiating pattern, not a generous one. So I always say, find that sweet spot, be high enough or low enough that you can make concessions and set these expectations, playing into this anchoring effect, but not so extreme that you create this insulting, negative negotiating environment. So keep that in mind. Keep in mind, we got to get what we want. We need to be, selling it as gains, trying to tap into this likability. It has a strong impact. And keep this in mind when we're negotiating so we can enhance the outcomes for our clients. All right, so I want to open this up also to Barbara and Ramona to get their input on this and to see, do you notice any difference when lawyers are getting along and acting civilly with each other rather than having an acrimonious type of relationship?
Barbara, did you want to start us off on this one? Or you're on mute.
I think lawyers come in getting along if they're prepared. It's so important to prepare ahead of time. You can't come to mediation and says, okay, I thought about this on my way here driving in, and I think this is the right number. So I think preparation is the key to having your own, to be confident in your own proposals and working with the other side. But if you haven't done any background and you haven't prepared for the mediation itself or prepared the case, let alone the mediation, you're not going to get along with the other side because you're thinking the other side knows more than you. He's going to find out you don't know as much. And it starts out bad. Not that it can't circle around, but it's going to take a little while longer, I think.
I absolutely agree with preparation. I think it's the most important factor in getting a good outcome for your client is preparing and knowing the strengths and the weaknesses and what the other side's looking at and thinking about, and what it is your client actually wants. Sometimes it's a creative type of resolution. Sometimes it's all about money, but really understanding. So I love that. And Ramona, what do you notice in terms of civility and the impact of that? And also to both of you, another question would be, what is your advice to people when they have somebody who's really difficult to work with on the other side? How do they protect their clients if they're in that type of situation? So Ramona and Barbara.
Okay, so I'll answer the first question first, and then we'll go from there. So, with some attorneys who are not civil, do I think it affects the mediation or the settlement conference? From a mediator or settlement judge's perspective, I would say not necessarily. As a mediator or a settlement judge, we know immediately upon the filing of these briefs whether folks are getting along or they're not. Let's face it, these briefs, when they say he's a liar or he's untrustworthy, he should be reported to the state bar. We already know there's a history there. So from that standpoint, I know one strategy that I'm probably not going to employ is putting counsel in the same room with each other. Because I don't know that until we're at the very end and we're trying to work out details of the agreement, I don't know that that would be productive. And sometimes it's, you're putting on somewhat of a show for your client. You want to show the client that you're tough. I get that. We all get that. And so that's okay. But I think the strategy that I might employ is maybe slightly different because I know someone might be a little agitated. And I don't take it personally. I don't think any mediators or judges take it personally because there's a lot that goes on during litigation. And so we get that you come in and maybe you're agitated by something someone said, something in a letter, something in some document filed with the court. So if someone's raising their voice and shouting, basically, as a mediator, we never shout. We just wait for you and try to get you to calm down. That's part of our job. And although I will say, I have said, calm down when I've had an attorney say, well, that's it, we're leaving, we're not going to get anything done. And what I usually say to them is, hey, look, you paid for me for another 3 hours. Why not use it? I'm happy to talk to you for as long as you're willing to talk. And even in those cases, and I've had several where someone said, that's it, we can't talk to these guys, they're unreasonable, they all settled. But they settled because people started to calm down, and it became less about being mad at the other side and trying to get a result for their client. So I don't think that it necessarily makes a difference. I think it just is a difference in the strategy that a mediator might employ. What was the other question? I'm sorry, Stacie.
Yeah, one thing I just want to add on to that, because I love it so much, that, I call counsel typically before a mediation to understand if there are these types of dynamics between counsel. This does change how we message. This does change potential process and format. So be there if your mediator doesn't call you and there's something tricky there, make sure to communicate that with the mediator, because it does change how we message, what we say and how we say it, and the format. Is it in a question or a statement when we're communicating information? So I love that you bring that up. And the other pre-mediation thing that it made me think of was the mediation brief. So us mediators, we love you to share mediation briefs. Not only does it save time, but it helps people understand perspectives. If you are sharing mediation briefs, which I think goes to likability and like good faith effort to get this case resolved type of spirit, make sure to take out toxicity when you are sharing your brief. Some of the name calling or insulting, or I'm going to annihilate them at trial, those types of things can be incendiary and unproductive for settlement. So if you're sharing your brief, you could always give your mediator a different brief than you want to give to the other side. I say, edit it, take out what you want to take out, but be careful with that language. So thank you for that. Also, I was asking you both if you have any advice when somebody, and I love this perspective for lawyers as they're going to trial and they have just a jerk on the other side. They can't communicate with this person, and it's just condescending, or it is name calling and insulting. Do you have any advice for them in how to approach that?
Do you want to start off, or do you want me to go? Oh, you're on mute.
Barbara, you're on mute.
Well, you're asking how a lawyer should respond to the other lawyer, right?
Yes.
Probably the same way a judge responds to a lawyer that's going off. Just, nod and I understand, and just go straight by the book, because it's hard for someone already in that mindset to get out of that mindset. And so once they're there, I haven't practiced law in years, so I just really have the experience of being a judge for the last. As you said earlier, I'm not offended, and I think the best way to counteract that is to speak softly. The louder they get, the quieter you get, and nod and say, okay, well, this is what we're going to do. I'm sorry you disagree, but this is how we're going to start it. And don't get into arguments with them.
What about you, Ramona?
I absolutely agree with that. You always should take the high road. And, that sort of behavior spills over into trial. And if you're in a jury trial, that sort of behavior is going to bubble up at some point or another in front of the jury. And the jury is just not going to like opposing counsel. Especially, that's why you have to be careful when you cross-examine people, how you do it. Is shouting going to help? If you've got a really good point, it's going to get lost if all you're doing is yelling, right? But if you speak slowly and calmly, and then somebody says something that that you can trick them into saying, and because you're doing this, and so this happened, and so then what happened next, and then next, boom, there it comes, and all the jurors' eyes are with like saucers, oh my God. So I think from a litigation standpoint, I think it's always better to take the high road. I'm a member of the Inn of Courts, have been for years, and I think that's one thing that they always talk about is civility. And when you take the high road, you're always going to be better off. Constantly coming in and fighting and yelling and screaming never helps the case. And if the lawyers are doing it in the courtroom, the judge is just going to sit there, listen to it, and is still going to make a decision, based upon what the law and what the evidence shows. So screaming it and calling the judge names, by the way, that doesn't work either. I've had that happen plenty of times where I've been yelled at for 45. It happened one time downtown at Mosque where I was yelled at for about 40 minutes on a motion. And then at the end, the fellow says, "And so, Your Honor, I respectfully request that you reconsider your ruling." And I just kind of said, "Okay." I took it under submission, and the next three motions said, "We submit." I don't think they were worried that I might be in a bad mood after that. But as judges, and we're just going to, whatever happens, we're going to be neutral and we're just going to listen. But it's not going to make your case better by raising your voice. And so I think taking the high road is the way to go.
All right.
And their clients aren't gonna, you imply that their clients are making them do it, or they're posing for their clients, but their clients see what's going on, even the, not as informed client kind of knows what's happening.
Although I will say this, a lot of times that sort of posturing and arguing and loudness comes because the client is in the courtroom. And the few times I've had it really get crazy, when the guy went to go out, he picked up his bags, and then there were like three people, and I looked and I go, "Oh, that must be Mr. Smith, Mrs. Smith, and the child." And then off they walked. And that's okay. I get it. I mean, we were all litigators once too. So we get it. And I think opposing counsel, you just have to take it. It might make discovery more difficult. It might make a lot of things more difficult. You follow the rules. If you have to file a motion to compel, you file it. But you show all the chances you gave the person and do it all in writing. If a person is going to just yell at you all the time, put it in writing. When I was a lawyer, I had a defamation case, and this fellow would call me up and just scream at me. And I literally put him on speakerphone because in order to be heard, I'd have to raise my voice. And I'm not somebody who raises their voice. And I didn't want anybody else in my firm to think I'm some crazy person that is, yelling. And literally, attorneys would come down the hall and they'd look at me and mouthing, "Who is that?" So, I get it. I've had that on the other side too. And it can be difficult, but you can protect yourself, and the judge will see it.
Yeah. Well, great. Thank you for that. All right. So we want to mention a few other things lawyers can do to get the other side to essentially give you what you want. And a lot of this refers back to this Robert Cialdini, who's talking about influence and persuasion. One thing that you wanted to keep in mind is this concept of consensus or social proof. That means that people like to do what other people are doing. So they've done a lot of studies in this regard. One of the more recent studies was in a hotel bathroom, and they put up a sign that said a majority of our guests recycle their towels. They got 28% more compliance with recycling than when the sign said, "Please recycle, it's good for the environment." Now, they've done this in a lot of different concepts, and the general principle holds true, is that people want to do what others are doing. So that's a great thing for you when you're trying to get somebody to accept your settlement proposal. Talk about other people who like the terms of this agreement. If you're a commercial developer and you're getting lease agreements on these terms, frequently share that with them. If there are comparable verdicts, that can have a persuasive impact. Or what other real estate prices are going for in the neighborhood. Depending on the subject and the context of your dispute, look for that. Look for what other people are doing when you're trying to sell your settlement proposal. Another thing that people like is certainty. And we know that people spend great deals of money to try to get absolute certainty. So that's a great thing for settlement, right? We frame language, settlement is certain. Trial, there's tons of risks, right? Your decision maker comes with their implicit biases. They don't even know about it, but they may not like redheads or people that are skinny or people with the name Stacie because based on their past experiences. And they come with their headsets. So if they were a landlord or their sister was a landlord and got screwed over by their tenant, they may not like the landlord. So all these lawyers put in all this energy about how they're going to prove different nuances. The truth is, if you're in front of a jury, you are going to take a huge risk, right? And we talk about this in mediation with you, but settlement is certain. And so if you're trying to get them to take the deal and this amount of money, talk about it in terms of certainty, because we know it has an impact. Now, this relates to this concept of risk aversion and loss aversion. People are risk averse in general. Now, we all have different risk tolerances. I don't like risk. I don't even gamble in Vegas. It scares me too much. But others are willing to gamble everything and gamble at trial and whatnot. As a general principle, studies show that people are risk averse. They rather have certainty over taking a risk. So you'll notice mediators, we talk a lot about that in a mediation. If you're not using a neutral and you're trying to get someone to take your settlement proposal, talk about risk and talk about certainty. Keep in mind, people are loss averse, and they are more strongly loss averse than they are risk averse, like 4 times more likely. And that principle is basically people rather take a gamble over a sure loss. Now, this can be problematic, right, for a defendant who's saying, look, I'd rather gamble than pay $100,000 in this settlement. So what you want to do, and this goes back to what I said before, is talk in terms of what the gains are. If they feel like they've made some gains here, it doesn't feel like a loss. So tell them why, show them how much you've moved, show them all the benefits of taking this deal so they feel there is a gain to this deal. So keep that in mind with certainty. We have a few more minutes. Scarcity. People want things that are in limited supply. Now, there is a master negotiator, highly recommend him, Chris Voss. He wrote Never Split the Difference. He does the master class, if any of you subscribe to that. And he even says, like, make your offers in demand with a time limit. I call these exploding offers. You play with this concept of scarcity as to time. So scarcity is basically if there's one concert ticket, you're going to want it because there's only one left. That's similar to the consensus. Everybody else wants to go to the concert. Maybe I should go to the concert too. But also if it's not readily available, people say, oh, this is high value. Make time a scarce commodity. So when I do a mediator's proposal, I always have a finite time that it ends. A lot of people talk and say, you have this offer for today, but tomorrow I'm going to be spending a bunch of money. This offer is not going to be open. Once I get more discovery, I'm going to reevaluate the case. Today is your day to take the deal. And you'll notice some of this. Look, cases settle. You'll notice at the end of the day, partially that's because you're out of time at the mediation. The other part is now they've gone through the negotiation dance and they feel the gains. Cases settle right before trial when you're out of time to settle. So play with this concept of scarcity. You can use it with time, and you can use it with other things that relate to your dispute. Another concept quickly is triggers. This concept is, and Cialdini talks about this, the more information you provide, the more likely someone will comply with your request. So if I went to the neighbor and I said, can I borrow your bicycle? They'd look at me like, what? Why? You have your own bicycle. But if I explain to them my bicycle's broken, it's in the shop, I promised my daughter we'd go bike riding to get ice cream, I'll return it in an hour, I have a lock. The more information I provide, the more inclined they are to comply with my request. So I know that, and in a mediation, as I try to extract concessions, I do share information before trying to get more movement. A lot of it is information management when you're entering into a negotiation. Use information at a time it can be impactful so that you can extract concessions with this information. Okay. And do you have anything to add? I think that takes us to the end of this. All right, Hayward's back. You popped back in. And thank you all so much for your attention. I know it's a long, long day.
Thank you.
And there were a lot of questions on the Q&A, and I guess since there were so many, we'll just take all of those later. Is that what we will do, Hayward?
Yes, for those that I have the email addresses for, or unless Judge C, you have a particular one that you want to answer right now?
Well, I just remember there was one towards the end where they mentioned that I had said, well, if you know the judge so well that he or she is going to know that you're always telling the truth, maybe that person shouldn't be your judge and they should recuse themselves. Remember, all three of us on this panel come from Los Angeles County, the largest trial court in the world, okay? So there is a really big chance that you're never going to see us again in a trial, or it's going to be 10 years from now if we were still judges, okay? And same with your opposing counsel, unless you're in a specific area of practice like employment law or entertainment law where you see each other all the time. In a small jurisdiction, you're right. I can't remember the name of the person or if it was anonymous. You may know everybody in your county. You may come from a county where there are only 2 judges. So, and they do everything in that county. You may belong to the same church or synagogue. You may go to the same movie theater, the same restaurants, because there's 3 of them. So, in that situation, it's very different. So the answer really is it depends, and it depends on that level of knowledge and familiarity, and that's up to the judge to really have to disclose that at the beginning of the case. I'm a member of the Inn of Court as well. This person was a member of the Inn of Court. I always disclosed, not just every person in the inn, because there are hundreds of people in your inn, depending on where you are, but I would disclose if I was a master with that person in certain years and how long it's been. And I would also disclose that, hey, I see them once a month at a meeting when there's a presentation, I say hello. I just did it on a mediation last week. I said, hey, I know this firm because this principal is in my Inn of Court, but that principal is not a part of this mediation. But I disclosed it so that all sides would know and they could make an informed decision. I think that's really what it's all about, is always making sure you disclose and make an informed decision. So
All right,
sorry about that.
Jesse.
And I do want to thank all my panelists. They were fantastic.
And I would like to do the same.
Right on the dot at 5 o'clock today. So thank you, presenters, and thank you all for joining us today.